Good afternoon, a very warm welcome to this construction and engineering webinar, which is brought to you by Birketts Solicitors. My name is Stefan Harris-Wright. I'm a partner in the firm and I head up the construction and engineering team that we have within the organisation. So this is our spring update for members of the Chartered Institution of Civil Engineering Surveyors. And big thank you to the CICES for inviting us back to present to you again this afternoon. So the theme for this session is, as you can see from the opening slide, smarter risk management in a turbulent construction market. So with everything that's going on from a kind of geopolitical standpoint in the world at present, it seemed like a sensible time to kind of summarize some of the key themes that we're seeing around risk management from a legal perspective. Now, I appreciate we often have something of an international audience attending these sessions, which is fantastic. So the material that we're going to cover is primarily kind of UK centric, but I'm confident that there will be some kind of consistent themes across what we're going to talk about, which are of relevance to delegates in other jurisdictions. If we could have the next slide, please. So if you haven't come across Birketts before, there's a bit of information about us at a glance for you on this slide. I won't go through all of this in detail, but you can have a look at that at your leisure afterwards if you'd like. But just in summary, we're a full service UK top 50 law firm. We've got 7 offices across the UK in the east of England, London, Kent and Bristol. And as part of the organisation, we have a specialist construction and engineering team. Next slide, please. So I am joined this afternoon by 3 colleagues from my team in the construction division. They are Chris Pedder, Kasia Dickson and Alex Terry. Next slide, please. So just to briefly summarize what it is we're going to cover in terms of content this afternoon. So Chris is going to talk about issues relating to price and program. Kash is going to cover off security and what security works and what perhaps doesn't. And then Alex has got our traditional update on any interesting recent construction and engineering cases. And the sort of theme for that part of it is cost-driven drafting and where that can go wrong. We'll also have some time at the end for a bit of a Q&A with our panel. But before we dive into the detail, just a bit of housekeeping for you. So there's an opportunity to put your questions to our panel through the Q&A function in the Teams portal. So please do send through any queries you've got or any observations. Always good to see those. We've had a few questions in advance from people, so thanks for those. We'll get through as many of those points as we can. And then I'll look to draw proceedings to a close promptly by 1:30 p.m. UK time. And then finally from me, before I hand you on to the first speaker, this session is being recorded and will be circulated to delegates by the CICES afterwards, along with a copy of the slides. If we could have the next slide, please. And on that note, without further ado, I will hand you over to Chris to talk about programme.
Thank you, Stefan. Good afternoon, everyone. When I chat with project teams about contracts, more often than not, we come to the conclusion that the cheapest price and the tightest program can be the most expensive way to build. I wonder why that is. Yes, there may be issues during the construction phase, but there are issues that are overlooked at the outset that build in false economies into the procurement. And when we talk about false economies, what we usually refer to is tender submissions that look efficient, robust or commercially disciplined at tender stage, but which convert into cost, delay and dispute later. Why is that? Well, one of the issues we see in operating contracts and assessment of risk is an overconfidence in how the contract will operate in the real world. Now, a classic false economy to me is assuming that the lowest fixed price and an accelerated program with a limited float will deliver certainty. What we do see is that the lowest initial price and the most optimized program can actually increase the final outturn cost. And that's because risk hasn't disappeared, it's simply been put into another pot. Next slide, please. So let's begin with price. Are fixed prices these days fixed in any real sense? Contractors will usually deal with uncertainty in one of 2 ways. Either they price the risk defensively by embedding premiums into risks and prelims, which inflates the contract sum from day one, or they price optimistically, intending to recover later through the contractual machinery, there's variations, claims, and then there's an increasingly intensive contract management. None of that is efficient. It just adds cost, consumes management times on both sides, but also, just as important, it damages trust between the parties. I think the same applies to program. Highly optimized programs often look impressive at tender stage, but they can be frequently fragile. They assume everything goes right, prompt decisions, perfect information flow, instant approvals, and no disruption. There's little or no float and very limited tolerance for change. There is a risk that when works are progressing, the program starts to unravel. At that point, the program isn't being used as a delivery tool, it's being used retrospectively to support entitlement arguments around delay. As a result of this, you end up with higher final cost, delayed delivery, and a project team that spends far more time managing claims than managing outcomes. So the key takeaway here is that price certainty or program efficiency are bad objectives. Not necessarily, but it's pursuing them without properly allocating and managing risk is a false economy. Next slide, please. So having talked about false economies in price, let's focus perhaps on one example of where we see that play out in practice, which is fluctuations. The typical approach we see is to disallow fluctuations entirely in order to fix the contract sum. And from an employer's perspective, this feels sensible. It's certainty up front and no exposure to inflation risk. But in reality, does the employer get certainty? When fluctuations are disallowed, contractors won't absorb inflation risk. As mentioned on my previous slide, they manage it through either pricing defensively into rates and prelims, or it's priced optimistically with the expectation that it will be recovered later through EOTs, variations, or loss and expense. Neither outcome should be particularly attractive to employers. One increases the initial price unnecessarily, and the other stores up disputes down the line. So while the tender looks competitive, the contract becomes more adversarial by design. A more balanced alternative is to think about selective index-linked fluctuations rather than an all-or-nothing position. In practice, this means identifying external inputs that the contractor can genuinely control. Particularly relevant at the moment are things like fuel, steel, and other volatile commodities, and allowing a limited fluctuation only for those elements. And then at the same time, you can sensibly exclude contractor control costs such as overheads, profit, and productivity, which are the risks that the contractor is best placed to manage. I think the exposure can be capped, and crucially, it can be made symmetrical. So it works both ways. If prices go up, the contractor gets limited relief. If prices go down, the employer benefits. And when this is done properly, the benefits should be fairly tangible through competitive pricing and less pressure on loss and expense claims, because the inflation risk has been dealt with transparently rather than indirectly. So key message here is that trying to eliminate fluctuation risk entirely can be a false economy. A targeted, controlled fluctuation mechanism can deliver better value, greater fairness, and fewer disputes. Next slide, please. So as regards programs, at tender stage, programs are often presented as highly optimized documents that can look attractive, but there are some perhaps clear warning signs that a program may be unrealistic. Common indicators include zero float, very compressed lead-in periods, and sequencing that is heavily dependent on approvals. Design sign-off, information release, third-party consents, without those risks being properly acknowledged or built in. On paper, these programs can look deliverable, overlapping activities that suggest lots of intensity and efficiency, but they often rely on everything going perfectly from day one. And perhaps, as we all know, involved in construction, that rarely happens. The real difficulty then arises later when the project is underway. If the original program is fundamentally optimistic, it can end up being used retrospectively, as I previously said, not as a management tool, but as a weapon. Contractors may rely on it to argue entitlement to EOT for delay on the basis that relatively minor issues have pushed an already tight program beyond recovery. And that then leads to disputes about whether the program was ever realistic in the first place, or whether entitlement should be judged against what was actually deliverable. Now, I think that debate is almost entirely avoidable, and the key is to focus less on achieving the shortest possible duration and more on program robustness. And that means looking carefully at how much float genuinely exists, whether float is transparent and properly allocated, and whether the sequencing reflects how the project will actually be delivered. It also means stress testing assumptions at tender stage, rather than accepting them at face value, particularly around approvals, interfaces, and access. And a program that is slightly longer but realistic and resilient will almost always outperform an aggressively compressed program that maybe collapses at the first point of pressure. So my takeaway then from this particular slide is that a fast program is not the same as a deliverable program, and prioritizing realism and transparency at the outset is far more likely to reduce delay disputes. And next slide, please. So this particular slide looks at a very common and very avoidable source of dispute, that one that regularly makes it to the courts, and that is the gap between what was clarified at tender and what actually makes it into the contract. So tender clarifications can be quite extensive. They deal with points that materially affect price, risk, program, things like scope boundaries, sequencing, access arrangements, and how approvals are expected to work in practice. But the problem is when these clarifications sit outside the contract and exchanged in tender correspondence, relied on to secure a price, and then completely forgotten about when the contract is executed. Now, a failure to either include in the contract or actually incorporate clarifications but fail to address the impact of including them creates plenty of scope for disputes. From the contractor's perspective, the argument is usually we price and program on the basis of those assumptions, but the employer counters by saying, well, if it's not in the contract, it doesn't count. And once you've reached that point, positions tend to harden very quickly. So the key then to avoiding that situation is relatively straightforward, but it does require discipline from project teams. The first step is to identify which clarifications are genuinely material, those that affect scope, sequencing, access, approvals, rather than the minor commercial points. And once identified, these need to be converted into binding contractual mechanisms. And there's a couple of ways of doing that. Safest option is to amend the contract documents, particularly the specification or employer's requirements, so that the clarification forms part of the defined scope. Another option is to include a referenced schedule in the contract, expressly making key clarifications and giving them contractual status. Now, I'm aware that can be quite complex, so maybe a hybrid would be to amend the contract documents with material clarifications, leaving minor items to be scheduled. Final option is maybe to turn these clarifications to express assumptions, making clear the basis on which the contractor has priced and programmed the works, although this is something I don't see very regularly. I think overall what matters is not the form, but that the outcome ensures certainty. Everyone should understand which assumptions have been accepted, how risks are allocated, which are still live, and how departures on those assumptions will be dealt with. So the benefit of that should be that it reduces the scope for arguments about whether risk was priced, and it narrows the bandwidth for variations in claims. So the takeaway from this slide is simple. If a clarification materially affects price or program, letting it sit outside the contract is false economy. However, I want to give you a word of warning. Do not simply set clarifications out in a schedule without assessing the impact of each one. This runs the risk of incorporating conflicting obligations within the contract, which again can lead to disputes. And I mentioned at the top of the slide that the courts have recently heard several cases, and I'll leave you with two examples as a warning. First was a case last year, John Sisk versus Capital and Centric, where there was a dispute regarding damage to existing structures, but the physical contract contained one clarification schedule, while the electronic version contained two tender submission clarification schedules with conflicting items. So after an adjudication fell in favour of the employer, the courts overturned that and concluded that the tender submission clarification document was not the relevant clarification document, and therefore the existing structures was an employer's risk as set out in the contract clarifications. The second case was Clancy versus E.ON from a few years ago now, 2018, where as part of its tender submission, Clancy set out certain exclusions that were not included in its tender, including adverse ground conditions. And the contract itself defined the works as those works set out in the numbered documents attached to the contract, which was all very good and the right thing to do. However, those numbered documents had simply incorporated Clancy's tender submission, including the exclusions, and post-tender meeting minutes, which also refer to the same exclusions. So inevitably, when adverse conditions were encountered, Clancy claimed additional costs. E.ON disputed this, went to adjudication and was successful. However, Clancy then went to the court to seek a declaration based on its understanding that it had excluded items in its tender. Now, in the court, E.ON, as the employer, argued that under the contract, in the event of any conflict between the contract documents, the conditions of contract apply, but also in addition, the contract contained a provision that Clancy were not entitled to any time extension or additional payment due to a failure to discover or foresee any risk or contingency, including the existence of any adverse physical condition, influence, or affecting the contract. That sort of type of provision, not unusual, I've seen that before. However, despite those contract provisions, E.ON lost at court, which held that the numbered documents contained Clancy's tender submission and that the post-tender meeting minutes and that the works were defined in the contract did not include the items that are excluded by Clancy. Therefore, the terms of Clancy's exclusions took precedence over the terms of the contract. So the takeaway there, of course, is making sure at the outset that the clarifications actually reflect what the parties are anticipating. Next slide, please. Finally, then, I just want to look at an area we frequently see good projects generate unnecessary costs and conflict, and that's the way variations, EOTs, and loss and expense are operated. The starting point is that problems here are rarely about the wording of the contract. Standard forms, I think, generally provide workable mechanisms, but the issues arise as to how those mechanisms are actually used during delivery. A very common example is where instructions are issued without any real program context. Something changes on site, an instruction is given, there's no discussion at that point about what the impact it will have on sequencing, critical path, or float. Now, the failure to discuss this impact at this point can lead to issues later in the project when the impact on the program is only addressed much later. Positions become defensive because of risk to time and cost. Employers may be reluctant to accept delay, and contractors may feel a bit forced to frame the change in the most adversarial way possible. The same also applies to EOTs. If extension of time claims are assessed late or once delay has crystallized, by then it might be harder to separate cause and effect, and the assessment then becomes an exercise in claim analysis rather than good project management. Loss and expense claims suffer from similar problems. If assessed late and presented to the employer long after the event, they will probably lack contemporaneous records, making it difficult for employers to engage constructively, and therefore it's easier for disputes then to escalate. So all of this can be improved with a relatively straightforward change in approach, and the first is to create a clear and continuous link between an instruction, its valuation, and its program impact. That doesn't mean resolving everything instantly, but I think it means acknowledging the issue at the right time. Therefore, instruct early, value provisionally, and regularize the position later. Particularly, notice provisions need to be applied realistically. Notice it should align with when a party is actually aware of an issue, rather than being just used as a technical trap to catch people out. Should consider including early warning mechanisms within the contract terms which promote engagement rather than encourage defensive behavior. And third, there needs to be an explicit recognition of how float is being used. If float is impacted by changes to the works, that should be acknowledged openly and dealt with at the time rather than ignored. Once any float is gone, then the next delay, even if minor, pushes the program into critical delay, at which point the employer and the contractor may adopt sort of defensive positions until the program tips into critical delay. So the key takeaway from this slide is that running variations, EOT, and loss and expense process defensively is the false economy. And when those mechanisms are made to work as intended, the benefits are significant. So I think, therefore, in closing, I mentioned at the beginning that the cheapest price and the tightest program can often be the most expensive way to build. And I think, therefore, ensuring programs are resilient, clarifications are binding, and contractual mechanisms are allowed to operate more in real time, this can go a long way to reversing that trend. Thank you. I'm going to hand over now to my colleague, Kasia, who's going to talk about security.
Thank you very much, Christopher. Hello, I'm Kasia Dickson, and in this brief session, I will focus on vanquishing some common misconception about various security documentation in the construction context. Can we have a next slide, please? Good starting point is to consider what risks exist and then consider what tools are there to minimize the risk. Think about why do we need security? What are the problems that we are trying to solve? One of the key drivers behind any security required is the risk of a party going insolvent. This is not an exclusive driver, as you may also want to protect against non-performance or default by the contractor. However, overall, an insolvency is likely to cause the most disruption with limited chances of recovery absent any security. So continuing with the contractor's insolvency, if this occurs, then you will most likely be out of pocket. Subcontractors will most likely walk off the site. You may need to pay twice for any off-site materials that you may have already paid for. So in order to minimize those effects of those risks, you may wish to ensure that someone else will pay any cost associated with insolvency, or there is a pot of money that you can access. Typically, such security is sought via performance bond or a parent company guarantee. As to any subcontractors that you may wish to continue, you may want to use this is achieved by collateral warranties using step-in rights. Lastly, as regards to any off-site materials, you may wish to ensure that you have the title to any materials that you have already paid for, and this is typically achieved via vesting certificates. So these elements mainly cover the employer, but looking from the contractor and subcontractor's perspective, they will most likely be looking for payment security. As you will all be aware, good cash flow is key on any construction projects. Many operate on low profit margins where repeated late payment or non-payment could result in financial difficulties. In those circumstances, parties can utilize escrow accounts or project accounts, which mean that provided that stipulated conditions are met, payment is made. Could we have a next slide, please? So looking at these tools closely and starting with performance bonds, what are these? Well, performance bonds, what are performance bonds? They're fairly typical in construction projects, and they are generally for about 10% of the contract value. They could be quite expensive to obtain, and the cost will usually be passed to the employer. As such, they need to be factored within the overall cost of the project. They typically expire on practical completion, although some bonds may go as far as making good defects. That means that if there is a claim needs to be made before the expiry. In the UK market, these are typically conditional bonds. So a claim must meet conditions of the bond, which usually means that default has to be proven. So ultimately, one has to show its entitlement to monies under the underlying contract before any monies get paid. And this is often the crux of the difficulties. It's the understanding when one will get paid. So for example, in an insolvency context, one doesn't simply get paid because the contractor becomes insolvent, although this may trigger a right to be paid. One still needs to show loss suffered as a result of that insolvency. And that often involves preparing a notional final account for the insolvent contractor, as well as the final account for the replacement contractor, making any allowances for omissions, variations, further instructions. And if the contractor becomes insolvent early in the project, then you won't be able to really do that final replacement contract or final account until quite late on. And meanwhile, you will need to find a way to finance the completion of the project. So as you can see, this is not a quick process. In addition, a bond provider is likely to require supporting evidence showing how an entitlement was arrived at. And this may be despite the fact that an additional costs may exceed any amount of the bond. So it is clear to see that the key limitations of a performance bond is the fact that they usually capped well below the true value of any losses that may be suffered, And there are various obstacles in making a claim, meaning that there may be quite some time from when the losses are suffered or when, for example, insolvency happened until you get the money paid into a bank account. Moving on to the next slide, and parent company guarantees. These are contractual promises that the parent company will perform obligations and or cover liabilities of the subsidiary. The extent of the protection depends on the precise drafting, but typically these cover all liabilities of the company. Expiry depends on the drafting, but often it covers the length of the contractual liability, that being the 6 or 12 years. So you can see that on the face of it, the possible liability and duration is longer than that offered by a performance bond. In terms of the value of the losses that you may recover, these are typically uncapped, and the costs involved in setting up or obtaining a parent company guarantee are limited because they mainly involve any possible legal costs in drafting the document itself. So they are more cost effective than performance bonds from that aspect. Some key drawbacks of parent company guarantees are that they are only as strong as the parent's balance sheet and jurisdictional reach. So in other words, if a parent company has no assets, then the parent company guarantee is going to be limited. In the same way, if a parent company is based outside of a jurisdiction or any assets that it has are also based outside of jurisdiction, you may have some difficulties in getting to the money. As such, if you are considering having a parent company guarantee, then you need to ensure that you carry out thorough due diligence. And that's not only on the contractor or company you're contracting with and the parent company, but also on a group as a whole. This is because it's not unheard of that where a company in the group goes insolvent, that the whole group may become insolvent. Moving on to the next slide. As regards any offsite materials, typically a contractor will not be entitled to be paid for materials that are offsite, or in fact materials that are not incorporated into the works. And this may expose contractors to paying large amount of money without ability to be of being paid for them. This often arises where large elements are fabricated off-site, for example in modular construction, or if orders need to be placed for long lead items. In those circumstances, the contractor understandably wants to get paid to aid its cash flow, but the employer may not want to pay without assurances that the employer is entitled to those materials. And the solution comes in the form of vesting. So vesting transfers ownership of goods or materials, and a vesting certificate documents that transfer. It's important to note that vesting certificate in itself is not enough, because in terms of the goods that are being vested, they have to be clearly marked and segregated. They have to be marked as belonging to the employer. There should be appropriate access rights and rights of inspection, and there must be an insurance that aligns with vesting. In addition to that, the contract needs to be quite clear at what stage the title to the materials passes. Is it at the stage where an application for payment for those materials is made, or is it when the payment is made? The key drawbacks and limitations are that the title does not equal possession. So in reality, if the goods have not been clearly identified or being kept segregated, then the vesting falls. Can we have a next slide, please? Next on the agenda is what to do to allow for the project to complete with the existing team and existing subcontractors. And that comes in the form of step-in rights. These are rights that allow typically employers, but also funders, to step into the shoes of the contractor and take over the subcontracts. This may be particularly useful if the main contractor becomes insolvent, as it enables the employer to step into the contractor's role and ensure the subcontractors continue to fulfill their obligation and limits any disruptions on the project. In reality, however, step-in rights are very rarely exercised. So although these are a good idea and most funders or most employers will require them, in reality, they're not really a solution. And on large projects, there may be various entities that have rights to step in. So you need to consider when can you step in. And the parties that have those rights to step in, they don't step in if circumstances arise because very often they're not equipped to actually operate subcontracts. Moving on to the next slide. So the tools that we have discussed so far were mainly for the benefits of the employer. Talking about something that may assist the contractors and the subcontractors is the escrow accounts and project bank accounts. They are ring-fenced payment structure protecting the supply chain. These are accounts that are held operated by third parties where monies are released on satisfaction of certain conditions. There are various ways in which this can be set up. For example, every single payment can be made from an escrow with an obligation for it to be topped up on a regular basis, based, for example, on a forecast project cash flow. Or, for example, there could be a certain amount sitting in there and a party can apply to have money released from an escrow account only if employer doesn't pay. So the very key benefit of escrow accounts or project banks accounts is that they could be very flexible and tailor-made to the circumstances required by the project. They provide for payment security and reduce insolvency leakage, because if a payment becomes due and if the employer goes insolvent, the contractor or the subcontractor will still get paid. There are, however, some key limitations in that operating an escrow project account adds to administration and additional paperwork. There are also additional costs because there are upfront costs of setting it up and ongoing costs for managing it. As such, they may be less suitable for smaller projects. And a key point to note is that escrow and project accounts do not magically circumvent any dispute about payment. So, for example, if a valid payless notice is served, then there will be no payment. Sometimes escrow accounts come under criticism for having very rigid release conditions, and then they're frozen if there is a dispute. But nevertheless, they do provide a good security for payment. So some kind of final thoughts on all those various securities is that there is a lot that is on offer, but whichever options you pick or combination of those options, it's not insurance. There's no guarantees. It's just covering or minimizing some of the risks. And when looking at the project and looking at the risks involved in the project and how to cover them, best to not only look from the commercial perspective or from legal perspective, but have both sides involved and then work out what's the best for the project. Thank you very much. I'm now going to hand over to Alex for a case law update.
Thanks very much for that, Kasia, and good afternoon, everyone. I'm Alex Terry, a solicitor specialising in dispute resolution in the Birketts construction team. And the purpose of my case law update today is to show you how 3 recent decisions that were handed down this year turn small drafting economies into very expensive outcomes. And then hopefully I can provide you all with some clear takeaways that will help you better manage these areas of risk. So each of these 3 cases will highlight 3 different pressure points. The first is the payment regime and termination and how notice sequences and payment mechanics behave under judicial stress. The second is who can actually use contract remedies, especially when projects are assigned. And the third is which companies can be pursued for cases concerning the Building Safety Act, where complex corporate structures can be of little use for company groups facing building liability orders. Next slide, please. So the first case I'm going to take you through is that of Providence Building Services Limited and Hexagon Housing Association Limited. By way of background, this was a dispute under a JCT Design and Build 2016 contract about termination for late payment. Back in December 2022, the employer missed the deadline for payment, and then the next day, the contractor immediately served a notice of specified default. And the employer cured the default by paying within the contractual cure period, which meant that the contractor never initially accrued the clause 8.9.3 right to terminate. Then sometime later in May 2023, the employer missed the deadline for payment again, and the contractor tried to terminate immediately by relying this time on clause 8.9.4, which is the repeated default route, arguing that the earlier late payment was a specified default that had now been repeated. The entire case boiled down to one short question of interpretation, which is, can a contractor terminate for repeated specified default when a right to terminate had never actually previously accrued? Next slide, please. So after adjudication and a first instance decision in the TCC going in the employer's favour, somewhat surprisingly, the Court of Appeal reversed the decision. However, the Supreme Court here unanimously overturned the Court of Appeal, and it held that termination for a repeated breach is parasitic on the right to terminate accruing at an earlier point in the contract. This means the contractor cannot terminate under clause 8.9.4 unless it has previously acquired, but not exercised for whatever reason, a right to terminate under clause 8.9.3. In plain terms, this means that there is no automatic hair trigger right to terminate for any repeated specified default or specified suspension event unless a right to terminate accrues from the first specified default. And this, of course, matters hugely because, as we all know, termination mistakes are binary. If you terminate without entitlement, you risk being treated as the repudiating party. So there's a few key takeaways here. And the first thing to note is that this decision will apply to 2024 JCT Design and Build Standard Form contracts. The Supreme Court emphasised the point was of general importance because this termination clause is so widely used in its standard form, and it continues in exactly the same wording in the JCT 2024 suite. The second takeaway, which we've heard all before, is terminate with care. This is another reminder to not treat termination as any sort of process shortcut. And on pressurized jobs, teams sometimes want an easy exit, and schedules of amendments are drafted to accelerate termination rights. But Providence is a reminder that courts will apply orthodox interpretation to the clause, and a rushed termination can flip liability entirely. The third takeaway is that payment and notice discipline is always cheaper than any legal argument later. This case only arose because payment cycles and notices were not treated as mission critical by the employer. In fact, the employer in this case actually missed payment 19 times to the contractor. Even if you're not terminating, late payment patterns drive disputes, and your lowest cost control is always operationally focused. Automate those dates, assign ownership, and make that notice sequence as foolproof as you possibly can. But just some food for thought on this case, and although that it has seemed to resolve the sledgehammer to crack a nut situation that the Court of Appeal previously left us in, where a contractor gained the right to terminate for just 2 late payments from an employer, even if those payments were just late by 1 day each. We are now, however, left in a circumstance where it doesn't appear that there's any incentive for employers to uphold agreed payment provisions, so long as late payments are cured within that specified default notice period. So this is something that could be considered when drafting your bespoke amendments. Next slide, please. The second case I'm going to take you through is that of Paragon Group Limited and FK Facades Limited. this time decided in the TCC. This was an enforcement case, and it was about a deceptively practical question, which is, can an assignee of the employer's rights refer a dispute to adjudication? The contract here was an amended JCT Minor Works 2016 form, and it was originally between Office Depot and FK Facades. It was later assigned twice, ultimately to Paragon. The contract had been amended so the employer could assign the benefit without the contractor's consent. Paragon then referred a delay dispute to adjudication, and they obtained an award. FK then resisted that enforcement, arguing that Paragon was not a party to the construction contract under the scheme. Next slide, please. So in their decision, the TCC held here that the assignee could adjudicate, and they enforced the award, which effectively confirmed that absent of any contractual restriction there might be, the right to adjudicate does travel with the assigned benefit. In the TCC's judgment, their wording confirmed that the use of the word party in the scheme did not have a conscious intention to differentiate between the position of an original contracting party and that of an assignee when referring to a party to a construction contract. Well, surprisingly, given the prominence of adjudication in the construction industry, no direct authority had yet addressed whether assignees could refer an adjudication prior to this case. So what are the takeaways on this one? Well, firstly, assignment clauses may not be boilerplate anymore. In a tight market, projects and interests move, and people treat assignment as a property or funding issue and forget that it's also a dispute resolution issue. Paragon is a reminder that if you allow assignment, you are likely allowing the assignee to use adjudication unless you exclude it. This can, of course, be desirable, but you should be deciding this consciously. However, as a second takeaway here, the TCC did expressly comment that this was a very finely balanced case, and permission was immediately granted for appeal. So it's very much a watch this space issue. The Court of Appeal is going to have to decide whether allowing the assigned party to adjudicate is fair based on the origin and the nature of the right of adjudication and its statutory intention, and also commerciality and fairness. Next slide, please. So the third and final case today that was very recently decided is that of Crest Nicholson Regeneration Limited and Ardmore Construction Limited. And this is a landmark Building Safety Act decision about building liability orders, or BLOs. The background in this one is that Crest engaged Ardmore, or ACL, to design and build a residential development known as Admiralty Quarter in Portsmouth. And in the wake of Grenfell, in the usual way, substantial fire safety defects were discovered in the external wall system. Crest referred the matter to adjudication for breaches of the Defective Premises Act 1972 and was subsequently awarded £14.9 million. However, and rather dramatically, ACL entered administration the day before the adjudicator's decision and ultimately didn't pay. Crest then sought BLOs to extend the potential liability from the now insolvent ACL to other associated group companies. They made two applications for two different BLOs. The first was that of an anticipatory BLO before final liability was determined at trial, and the second was an adjudication BLO tied to the unpaid adjudicator's decision. And the key legal issue here was whether the adjudicator's decision, despite only being temporarily binding, could amount to that of a relevant liability for BLO purposes under Section 130 of the Building Safety Act. Next slide, please. So in their decision, Judge Constable granted both BLOs, and it's being treated as significant because this indeed confirms that BLOs can in fact be brought at any time and can be made before final liability is determined, which gives it now an anticipatory nature. And secondly, that an adjudicator's decision can in fact constitute a relevant liability under Section 130 of the BSA. So adjudication and BLOs can now operate together. So the key takeaways for this one are that firstly, the court now does in fact have that ability to make an anticipatory BLO. And the BLO being brought before trial can serve as an important purpose for both claimants and defendants, because it can now clarify at an early stage whether solvent associates will have to stand behind the original defendant. And from a claimant perspective, it can give some guidance on whether that claim is going to be worth the candle. But do bear in mind the just and equitable test that attaches itself to BLOs. And it has been confirmed once again that this is a highly fact-specific test. And although it seems a relatively low bar to meet the just and equitable test, the court will have a wide discretion to consider each case on its own merits. And in this instance, obviously, it was held to be just and equitable to grant both those BLOs. Another key takeaway here is the impact on settlement dynamics. And one of the practical effects of BLOs is commercial. Once a solvent group entity faces joint and several exposure, their stance that they can't pay will likely soften. And Crest and Ardmore is therefore a good example of how legal tools can change settlement behaviour, and in fact why dispute strategy can be a cost-saving measure and not a cost. But as a final key takeaway here, beware of over-reliance on the use of complex corporate structures that may be created or set up in an attempt, as it may have been in this case, to try and distance group assets from their liabilities. Next slide, please. So I'll leave you with just some closing thoughts on each of the three cases. And the first from Providence and Hexagon is to remember that standard forms cut both ways, and termination is never a shortcut. If you want a safe project, invest in payment notice discipline rather than gambling on termination rights. The second from Paragon, follow the money and the remedy. In a market where contracts are assigned, check who can pull that adjudication lever. And remember that boilerplate assignment can have real disputes consequences. And third, and finally, from Crest and Ardmore, enforcement and solvency are part of risk management. Records, adjudication strategy, and settlement leverage are not extras. They're often what determines whether you actually recover the money. But do beware of the powerful policy purpose of the BSA to hold those responsible for building safety defects accountable, will likely to trump the attempt to murky the waters with complex corporate structures. Thank you for listening. I'll now pass you back to Stefan, who will now host a Q&A for any questions that have come in.
Thanks, Alex. So we don't seem to have had any live questions during the session, but there's still time to do that. So if you have anything you'd like to raise with me or our panel, then please do drop that into the Q&A function on the Teams portal. So for now, we'll run with some questions that we had submitted from delegates in advance of the session. So Chris, perhaps if I come to you first, a question about program. What steps would you take to interrogate a zero float program?
Oh, I think then the thing to do is to actually interrogate that with the contractor. So ask them to identify activities which don't seemingly have a recovery path if they are delayed, and maybe get the contractors to explain how delay is absorbed before completion affected. So this should allow a discussion on the risks within the program, and maybe even ask for a demonstration of impact on late approval or design delay. I'd also back that up maybe with inserting a clause within your contracts, talking about contractors submitting a detailed contract program for acceptance, and then just setting out the fact that it includes critical path float allowances, lead-in periods, and sort of design release deadlines, and then also include ongoing requirements to submit updated programs on a regular basis.
Okay, thank you. Kasia, I'll come to you next. There's a question here about bonds, but I think this possibly extends in some ways to sort of parent company guarantees as well. There's two parts to this one. So at what stage of the contract would you expect a performance bond to be put in place, at part one? And then part two, what remedies are available for a client when a bond or PCG is not delivered on time?
Yes, sure. Typically, we would expect either a parent company guarantee or a performance bond to be put in place at the same time as the building contract is being signed or shortly thereafter. If those documents are not provided, then that's a breach of contract. However, it is quite difficult to really enforce that. So typically what happens, we would add additional provisions to say that if parent company guarantee is not provided or a performance bond not provided in a time required, that we will there will be either a certain amount of money withheld from the contractor or no payment, there's no payment entitled until those documents are provided. However, typically when we get to a stage of executing the building contract, a contractor or subcontractor would have gone and sought quotes for provision of a performance bond. They would have agreed the terms of the performance bond. So at that stage, it is just a question of paying the money and getting the document issued. So there shouldn't be a reason why the performance bond or a parent company guarantee is not provided. Yeah.
Okay, thanks, Kasia. Alex, I'll come to you. Question about BLOs and RCOs. So what is the difference between a building liability order and a remediation contribution order?
Oh, yeah, good question. Well, they've got a lot of similarities because they both kind of come under that they both have that just and equitable test that attaches to both of them. But I guess there's a sort of obvious difference, which is a procedural one. Firstly, if you're bringing a BLO application, that has to be made in the High Court. And if you are bringing an RCO or remediation contribution order, that has to be made in the first tier tribunal. But they're both quite similar and BLOs were introduced with that purpose of trying to pierce the corporate veil to avoid the scenario where you might have a sort of thinly capitalized company with very little assets, which is sort of protecting a holding company which has got all of the money that you can go after. And the RCO is the same in that it's also designed to go after companies that might not be as directly involved in the project. But the actual times that you would use these two things is slightly different. So you might use a BLO when you're deciding which company to pursue for, say, a DPA claim, when you're trying to sort of figure out where your liability is and what company to go after, especially if there was an insolvency, like there was in the Crest case. But you might use an RCO if you're, say, acting for a group of leaseholders who are trying to get their fire safety defects sorted and have already started paying for defects and for remediation of defects, and then they're looking to recover those costs from a relevant party.
Good stuff. Thank you, Alex. Chris, I'll come back to you. Question here about tender clarifications, which you obviously touched on. Why do you think tender clarifications so often fall into a contractual limbo, and whose problem is that in practice?
Yeah, I think the issue here is, as I flagged in those cases I discussed, they sometimes fit into two difficult box, and there's an assumption that if you just simply attach the clarifications to your document, somehow you've fixed everything. And those court cases show that actually that's not the case. So there should be a disciplined process to review those clarifications. And that means, as I sort of talked about in the slide, you either physically amend the terms and conditions of contract or the employer's requirements or specification, because of course there might be a project delivery team that may be different from the procurement team, so it'd be easy for them in project delivery. The alternative is to attach a schedule with those clarifications in it, but it needs to be technically reviewed to make sure that there's no conflicts are being introduced. And I think obviously it's for both parties' benefit. If they're not clarified within the document and the assumptions of risk is different, then I think the court cases show that it was the employer that lost out. So I think that's a red flag and a warning for employers to make sure that where there are clarifications, they're properly incorporated.
Excellent, thanks, Chris. Time, I think, for one more each for Kasia and Alex. So Kasia, if I come to you first, how do you decide what security is required?
That's $1 million question. I think we just need to look at who is the client, what are the client's requirements, what is their appetite for risk, how much money they want to spend on getting a security, because if they want to make sure that they're secured as far as possible and they want a performance bond and a parent company guarantee and everything else, then obviously that's going to increase the costs, but doesn't necessarily end in a guarantee that all losses will be covered. So it is a conversation between the client's commercial team and the technical advisors and the lawyers. Typically, if there is a parent company guarantee, then you don't. If there is a performance bond, then you typically don't have a parent company guarantee at the same time. If there are offsite materials, then you typically would want a vesting certificate, but then it depends how much money you're spending on those materials. If it's an amount of money that the client comes and said, actually, I'm not really that concerned about 20, 30,000 pounds not being paid, but to some clients that may be a lot of money. So it is very much on a case-by-case basis.
Okay, thanks, Kasia. Alex, come to you now. So from the Paragon decision, what should a party do if it keeps receiving late payments?
Sure, yeah. So to just contextualize that and as a reminder, from that case, the Supreme Court has now confirmed that you can't rely on that repeated default under clause 8.9.4 unless a termination right has already accrued, which then leaves you in this awkward situation where if you keep having late payments from an employer, but they're paying within that specified default notice period, it leaves you with little leverage on actually how to get the employer to pay on time. So what you could do is just to make sure that you serve immediately that specified default notice, serve that the very next day as soon as possible to get that time running as quickly as you can, and then diarise the expiry of that notice period. And just remember that you can only start to consider termination once that specified default notice period has expired.
Good stuff. Okay, thank you to the panel. That's just about all we've got time for. Coming up to 1:30. I hope you found the session informative. If you've got any feedback for us, we're always really keen to hear about that. So if you do have anything to pass back on the session, then please do that via CICES. In particular, anything that you would like to hear from us about in future sessions, that's always really useful. Our next one of these sessions is going to be our summer update, which is scheduled for the 16th of June, and details for how to sign up to that will be circulated by the CICES in due course. So all that remains for me to say is thanks once again to the CICES team for inviting us to host the session this afternoon. Thank you once again for joining us. Have a good rest of your day, and we hope to see you next time.